Angela Landy is suing her former employee, Alishani Wyatt, for stealing clients and breaching their employment agreement.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2112, Landy versus Wyatt.
Thank you.
You're welcome.
Miss Wyatt, when did you become an esthetician?
I was licensed as an esthetician in March of 2021.
Okay. Miss Landy, this is what your case is about. You hired Miss Wyatt for your business. You have a spa business. Is that what it is?
Yes, I do, Your Honor.
How long have you had the business?
I've been in operations as an S Corp since 2016. I worked for myself as a sole proprietor since 2009.
How many employees did you have in 2020 and 21?
In 2020, it was during the pandemic. We were shut down most of the time. In 2021, there was up to 5 employees, not including myself, Your Honor. It was 6 of us total.
Does that include Miss Wyatt?
It does, Your Honor.
When did she start working for you?
She started working for me in February of 2021 as a receptionist. I hired her as a receptionist.
Okay. Not an esthetician?
No, Your Honor.
Okay. Were you going to school at the time?
I was not hired in February. I didn't get my license until March of 2021.
What the plaintiff says is you were hired in February. She probably has documents to work as a receptionist.
I was not hired. I didn't even have my license then.
Did you have any proof that she started in February?
Your Honor, I have proof that she...
Was she on your payroll?
She was on my payroll.
Okay, so that's
what we have document of in that is that she started brand new as a receptionist. Maybe it was in March of 21.
Okay.
I have my first paycheck stub.
I'd like to see it.
Okay.
This is a pay stub from April.
Yes.
Oh, okay.
Okay. This is your claim. Your claim is that when Miss Wyatt came to work for you, subsequently as an esthetician, which she was, because she counted her among your 6 employees in 2021, that she had signed a contract which provided for certain restrictions should she leave. You don't have that contract.
I cannot find it. It was supposed to...
Okay. You don't have that contract.
Nope.
Miss Wyatt, when you went to work for the plaintiff, do you recall signing a document?
I do recall signing documents stating like what my job title was and like the documents that would go towards what we went over and things like that for training purposes.
Okay.
Your Honor, I have non-solicitation, non-disclosure agreement documents of employees. There's 4.
Okay. Is this an employee of yours?
No, it is not, Your Honor.
Ever? Was ever?
Never been an employee.
Were either one of those 2 people employees, former employees?
Tabitha Brown was.
Was this a former employee of
Tabitha
yours?
Brown was a former employee.
At approximately the same time?
She was an employee of mine for 5 years up until April 17th, Your Honor.
Did she voluntarily leave or did you?
She voluntarily left.
Okay. Did she voluntarily leave to go to work with the defendant?
I did not know that until the day defendant left.
But ultimately
Yes.
you determined that she did?
Sure did.
Okay. She was with you for 5 years?
Sure. Yes.
I assume that if you have a business and you don't have this contract, which you allege if you could produce, had a specific non-compete clause in it, but you don't have it. She remembers signing something, but she doesn't remember exactly what it was. Can you stand up? Tell me your name.
Tabitha Brown.
Miss Brown, did you sign a contract when you went to work for the plaintiff?
Yes, I didn't remember that I did.
You did?
Yes.
But you did?
Yes.
Okay. Do you have a copy of her?
I sure do. And Your
Just a
Honor-
second.
Okay.
Do you have a copy of it?
I don't.
No, but you have a copy of what she signed?
Yes.
I'd like to see it.
Your Honor.
No. Just
Okay.
let me see the copy. I'm trying to reconstruct something just to get some general parameters of this case. Tabitha Brown, March 22nd, 2022.
Yes.
Different.
Oh,
That is not the non-solicitation, non-disclosure agreement. That's a different agreement. Those are contracts she has signed.
Oh, well, you gave me 2 things. What is this?
One is her non-disclosure, non-solicitation, and also the second one is the role definition of an esthetician working for me.
Looking at the non-compete. Okay, this is pretty standard. Kevin, would you show this to Miss Brown? And I also want you to show it to Miss Wyatt. that clearly your signature.
Yes, ma'am.
Yes. And so that says within 1 year of your leaving Miss Landy's employment, you will not work in a related field within 7 miles from her current place of business.
Yes.
When you left her employment, did you go to work with Miss Wyatt?
We left to share. Yes.
The answer is either yes or no. So you did. You
Yes.
went to work with Miss Wyatt. And when you went with Miss Wyatt, that was sometime in 2022.
Yes, ma'am.
What month?
May of 2022.
Your Honor, that's incorrect.
Shh. Don't. I'm not needing your help.
Okay.
In this case, you don't have a physical signed contract, so I don't see why you think that you have all documentation.
I don't have documentation.
That's what I'm saying.
Due to the fact that I believe she stole the information out of my filing cabinet.
Angela Landy claims her former employee, Alashani Wyatt, stole clients and breached their employment agreement.
Now, does Miss Wyatt have a location, a shop, a store, a place of business, or does she operate out of her residence?
We share a space
You share a space where?
at the Salon Studios in Valencia.
Have you calculated the distance between that space and Miss Landy's office?
I have, ma'am.
And how far is it?
3.4 miles.
Well, you're not allowed to do that, pursuant to the terms of your agreement.
Correct. I don't have a copy of that agreement, ma'am.
Well,
I have it now, but at the time I didn't. It's from 5 years ago, and I never received a copy of that. So it was.
I don't know whether you received a copy of it or not. It's your signature, and it's pretty standard fare. It's not that it's not standard fare. So, Miss Wyatt, what I have to do is sort of put together whether or not I believe that you, in fact, had the same document that you signed.
Correct.
And I believe that you did.
Okay.
Despite the fact she says that you probably took it when you left. I can't describe that conduct to her. But this is pretty standard fare, that within 1 year it's not too onerous, it's not within a 50-mile radius, it's a 7-mile radius. 3.5 miles are certainly well within that. You could have found some place that was 8 miles away, and then we wouldn't be in this difficulty. But you didn't. Anyway, so you were in violation of your contract when you left and went to work and shared space with Miss Wyatt. Okay, but you're not suing her.
No, ma'am.
Why?
Because I know the case would be dismissed because of the lack of solicitation between clients and of a former employee.
Well, not necessarily. Those two stand alone.
Your Honor, if I may say, there was a small claims action against Tabitha, but because there was no evidence.
What do you mean there was no evidence?
I had no evidence, the way I have evidence today with Alashani, that Tabitha solicited clientele.
Okay. Now you can sit down.
Thank you.
So that small claims case was dismissed.
Yeah, I have nothing there, which I learned. I have nothing to stand on what I have to stand on today.
Well, what you had to stand on, Miss Landy, which I don't understand, you had a non-compete agreement with her. She's in violation of that agreement. That's all you need. And she violated this agreement. She went to work within 7 miles of your place of business. So I don't understand that. In this case, you don't have a physical signed contract. I have to reconstruct whether I believe that there was one. So I don't see why you think that you have all documentation.
I don't have documentation.
That's what I'm saying.
Due to the fact that I believe she stole the information out of my filing cabinet.
I don't know whether she did or not. Right now, you say it's a lost document. You can't find it.
Correct.
Okay. And the defendant acknowledges, and it's usually custom and practice in the business, to sign a non-compete when you have that kind of service industry. Right. And I'm prepared to accept judicial notice of the fact that when you go to work for a beauty salon or a hair salon or a spa, you develop a clientele within the spa. You can't open up a store next door and steal the clients. Most people have people sign this, and you did, and you had it done 5 years ago. So Ms. Brown is in violation of this contract.
That is correct.
Why somebody dismissed that, I don't know. I have no idea. Okay. So now you're going to demonstrate to me that Miss Wyatt solicited clients of yours.
Yes,
Show me.
Okay. In July of 2021, Alashani was trained to be an esthetician.
Let's not go back to ground zero. I'm not interested. I am assuming for the purposes of this hearing that she signed a non-compete clause, just as Ms. Brown did. So let's start from there. And I asked you a very simple question. I said, what proof do you have that she solicited clients when she left?
Your Honor, my solicitation is here,
Fine, I'd like to take a look at it.
and my witness, Kennedy, is here as well.
Well, let's go to Miss Kennedy. Was Miss Kennedy a client of yours?
Yes, Your Honor.
Would you stand up, please? Your first name?
Kennedy. Kennedy.
Last name?
Johnson.
Ms. Johnson, how long had you been a client of Miss Landy's spa?
I want to say about 2019, Your Honor. I was there before the pandemic and was there for a while before it shut down due to COVID.
Were you there after it reopened?
Yes.
After COVID. What kind of work do you have done there?
I get sugared, which is using sugar, lemon, and I believe it's honey and water. And you mix it together and it takes hair off of you.
And who did that for you?
I went through many of the clientele and the employees at Angela's shop at the time. So there were several people that, Alicia was one of them, as well as Tabitha.
How many times did the defendant do the waxing? Sugaring.
I want to say at least 5 times.
Do you recall when she left Miss Landry's?
I do not remember the date. However, I do remember getting a call from her company. I got a call saying...
From Miss Landry's company?
Yes.
Yes.
Your Honor, it's Landy.
Landy.
Yes, from Miss Landy's company. They had called me on my cell phone and told me that she was no longer there. And they had told me she was no longer
You can't
there.
tell me what somebody from her shop told you. That's hearsay. I want to know about the solicitation. If there was.
Yes. So one point while Alicia, the defendant, was there.
Sorry. Do you understand?
Yes.
While the defendant was there, I had gotten sugared on my face. It was a small patch test, excuse me. And after she had texted me, gave me her personal number, and told me if I had any reaction to text her and let her know. After I texted her, I had...
And this was while she was working for the plaintiff?
Yes, that is correct.
Go ahead.
And as a while, I started having a small reaction, and I had texted her and sent her a picture of my face and told her that I was starting to have a small reaction. I did not receive anything back for a little bit, and then I want to say around April, late March.
Well, when did you text her?
This text for the face patch was earlier, I want to say early March, maybe February.
Do you have the text?
I believe she gave it to you.
The third one, Your Honor.
What date did Miss Wyatt leave your employ?
April 22nd is when I got her immediate resignation.
April 22nd, 2000.
22.
And is this what you're referring to? Hey, Kennedy, I forgot to tell you, if you wanted to book with me again, I could put you in my books. I'll be in Valencia.
That's correct.
And is Valencia where your shop is?
3.2 miles away, Your Honor.
No. Answer my question. I have a question. Is Valencia where your shop is?
No.
That's my question. Why don't you just answer my question?
Okay.
Tell me what she told your attorney. Do you understand?
Even if I have an affidavit?
Is your attorney in the military?
No, I just have a notarized affidavit.
From whom?
My
From
attorney.
Her? No, I don't take affidavits from attorneys.
Okay.
It's ridiculous.
Business owner Angela Landy has accused her former employee, Alishani Wyatt, of taking her clients and breaking their agreement.
So Valencia is not where your shop is. Valencia is where your place of business is.
Yes, Your Honor.
Okay. So you left on the 22nd, is that correct?
That's correct.
On the 20th, 2 days before, you tell Miss Kennedy, because I assume that this was a planned move of yours, that she can reach you again at your new place of business in Valencia.
Yes, Your Honor.
Okay, well, you're not allowed to do that.
During the services, it's a very intimate service, so you start to gain a relationship with these clients. And through that time, I felt like I had gained a relationship. It wasn't just a client with Kennedy. So
You met her
Yes.
through the plaintiff.
Yes, Your Honor.
You started to work on her through the plaintiff.
Yes, Your Honor.
She had other people work on her other than you.
Yes.
She may have liked you better than the other people. That doesn't diminish the fact that you knew that you weren't supposed to solicit clients. You knew that. I believe that you knew that.
Yes.
Because that's standard fare. So your excuse is you thought you developed a personal relationship with her.
Correct, Your Honor.
How many other people did you develop a personal relationship with?
Majority of the clients that I had who were returning clients of mine, I felt like I had built personal relationships with.
If you're potchking around with somebody's face or scrubbing their body or giving them a scrub to get hair off on every part of the body, then you develop an intimate relationship with
Correct.
somebody. Now, your first name is Kennedy?
Yes.
Kennedy, did you ever go out to dinner with Miss Wyatt?
No, I did not.
She ever invite you to her house?
No, she did not.
Was the only time you ever saw Miss Wyatt while you were having a service?
That is correct.
You see, that's not an intimate relationship. That's just stealing clients, Miss Wyatt.
Okay.
So my question to you is, you're seeking damages, okay? Did you seek injunctive relief?
No, Your Honor.
Why not?
I didn't know about injunctive relief. In addition, because of the staff leaving, because of solicitation, admitted solicitation by Alashani to my attorney, and I have a sworn affidavit for that. Because of that, I ordered them a cease and desist, and they ignored the cease and desist. Alashani told my attorney that she did not
No, you can't tell.
Hearsay.
You can't tell me what she told your attorney. Do you understand?
Even if I have an affidavit?
Is your attorney in the military?
No, I just have a notarized affidavit.
From whom?
My
From
attorney.
Her? No, I don't take affidavits from attorneys.
Okay.
It's ridiculous. Are you still in operation, Miss Wyatt?
Yes, Your Honor.
How many people work for, with, or to you?
It's just me. I have my own personal LLC, and she has her own personal LLC, so none of our money is combined.
Miss Wyatt, how many of your former clients from Miss Landy's business followed you?
I would say a good portion. I don't have an exact number.
Yes.
Here you go.
Now, just tell me.
I would say at least.
No.
No, I'm sorry.
I don't want you to say I would say at least. I assume you have names, people.
I have names and people here.
How many of your clients
20.
went to Miss Wyatt?
20.
Not was solicited. Follow me very carefully. Not solicited by her, but actually left your business to go with her.
Actually left my business to go with her.
20.
Yes, Your
I'd
Honor.
like to see. Does that sound right, Miss Wyatt?
Yes, Your Honor.
Then I don't have to see. She says that that's about right.
Your Honor, I would also like to add that after I left, she did send out a mass text allowing all of the clients who had ever seen me to be aware that I was no longer there. So that also allowed more clients to reach out to me in different aspects.
No, my dear, you made the mistake.
Okay.
You made the mistake by opening up an office within a 7-mile radius, which you can't do.
Okay.
You solicited her clients. I thought maybe just 1 or 2, but 20, that's a lot of clients. 20 recurring clients is a lot of clients. Miss Landy's request in her small claims case is the maximum of the jurisdiction, which is $10,000. And I think that she deserves every penny of that.
Okay.
Because what you did was wrong and a breach of your contract with her. Judgment for the plaintiff in the amount of $10,000. We're
Thank you, Your Honor.
This court is adjourned.
And I have to tell you something. That's ongoing,
Okay.
just so that you're aware.
I felt like the work environment was very unstable.
I have so many people to testify, including employees, that it's not a hostile work environment.
And I was constantly anxious there.
I was doing so much to improve the quality of the business by changing policies and procedures,
I had to do what was best for me and my family. I'm a single mom, so
hiring a business coach, working with an HR team.
let the better business win, I guess.
The better business is won.
I was a little bit confused. Maybe you can shed some light on it for me. Why the plaintiff wouldn't sue for injunctive relief, because injunctive relief is suing not so much for damages, but to get someone to stop doing something. So in this case, it seemed to me that the proper ask, per se, would be injunctive relief to stop the defendant from operating her business in violation of her contract. But she didn't do that. She sued for damages instead. And I just think that this same problem could keep happening, that I think it's a good lesson for people to educate themselves or hire a lawyer to find the proper relief. Because what's to say that this is going to stop today? I'm sure she'll keep seeing the 20 clients.
Well, she's going to keep seeing the 20 clients. This judgment today was more compensatory than punitive, because if she had taken one client with her, well, she's in violation of the contract, and some token violation would have been appropriate. But she took 20 clients with her.
I got the feeling from you that you weren't exactly in line with the $10,000 number until you heard
Until
about
I heard
20
the 20.
clients.
I mean, that's really
whole business,
some
really.
sort of chutzpah to knowing, and I believe she absolutely knew, she's a smart cookie, knowing that you had a non-compete because her friend, who she also took with her, had the same documents signed in 2017. So, and she's clearly a businesswoman, so that would be a consistent practice of hers. I don't know who took the contract out of the file cabinet. It's for another day. I reconstructed it. I actually don't know why she wouldn't sue for injunctive relief as well as punitive damages. It would have been an option for her.
Yeah.
Herman and Tina Smoody are suing their former son-in-law, Dalton McDonald, for unpaid loans.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2082, Smoody versus McDonald.
Thank you.
You're welcome.
Mr. and Mrs. Smoody, the defendant used to be married to your daughter.
Yes, Your Honor.
And according to what I've read, they were married for about 5 years.
Yes.
The thrust of your claim is that he owes for a couple of things, for rent and the balance of a truck. That's your lawsuit against him. I'd like to know, do you know the date of their marriage?
3/16/2011.
And your ex-wife's first name?
Jacqueline,
And when did you and your former wife separate?
in 2020.
And you had 2 children. How old are they now?
They are 5 and 8.
And who has custody of the children?
Dalton has physical, and they have joint custody.
Just a second. So he has custody of the 2 younger children?
Yes.
That's a yes. How long have you had custody of the 2 children?
Since July of last year.
At some point during the marriage, there was a truck purchased.
Yes.
Who purchased the truck?
Dalton purchased the truck. I co-signed for it.
And when was it purchased? Month and year?
June of 2017.
Was that the only car
Yes.
that they had?
Yes.
So that was a family car.
Yes.
And in 2017, was your daughter working?
Yes.
So both parents worked. And both parents, I assume, pooled their money and I assume made car payments.
Yes, Your Honor.
Yes.
Is that correct? Both. And then they separated in 2020, and at that time, the children came to live with you.
Correct.
And you took the truck
Yes.
by agreement with your now ex-wife.
Yes.
In 2020, who made the car payments?
My husband did.
Is that correct?
Yes. I made all of the car payments on that vehicle, all of them, from the time it was purchased until we paid it off.
Okay, so what you're telling me is from 2017, you made all the car payments.
That's correct.
Did your daughter and son-in-law make any of those payments?
Not directly, but they paid toward the balance of the money that they were.
You paid for the truck
That's correct.
since 2017, since they
correct.
were married,
Yes.
with no reimbursement.
I took payments out of my daughter's check.
Just be very, very careful with me, sir.
Yeah.
I want you to be very careful with me. I read that, what we call in Yiddish, Bubba-meises in here, that you took money out of your daughter's check. Bubba-meises, it means grandma's tale. It means it's not true. It means it doesn't sound right to me. I read it in here. Don't try to repeat it here because that won't be good for you. Okay, I'm going to believe you if you show me copies of her checks that you made to her with withdrawals from money she owed you. That's all I want to see. Do you have that?
I do not.
Not, of course not. Now, he has the truck, and this was clearly either a gift or a marital debt. Either one of those 2 things. It's either a gift or a marital debt. It was a family car that was used by your daughter, her husband, the grandchildren, with, according to you, no reimbursement, according to you, except this ridiculous reimbursement from your daughter's check, which I don't believe, so I'm not even going into it, with no reimbursement 2017, 2018, 2019, 2020. And when your daughter and the defendant separated in 2020, according to him and according to you, he took the truck and the children. And that was with her consent or not?
Yes, it was.
With her consent. Is that so far right? That's what you're telling me.
It's accurate.
Right. Did you intervene in the divorce proceeding and say that there is money owed, marital debt owed, and part of the marital debt is this loan on the truck?
No.
No, no. The answer is no, you did not. It would also be fair to say that you don't know how much, according to you, she paid for the truck.
I do, Your Honor. I have
Well-
that ledger that I have. I would go to her each week and say, Jacqueline, how much can I take toward the loan? And that's how much I would take off each week.
All you have to do, sir, is show me. Otherwise, this is a whole bunch of nonsense.
Yeah.
It's a marital debt. You did not intervene in the divorce proceedings and say, listen, this is a debt that's still outstanding, whatever it is, $2,000, $3,000, $4,000. You didn't do that. Now, the only thing that you can say to me with regard to this truck business is if you had, had an agreement with the defendant in 2017 to pay the truck. And be very careful, because what you've told me is he didn't make any payments to you from 2017 ever.
He made some payment.
Just a second. Interesting. Show me where he made payments. Did you give him a receipt for payments?
No, this is a small town, and
It's not a small town. It's a family, sir. It's not a small.
I do have the ledger.
I'm not interested in the ledger you created. It's self-serving and therefore inadmissible and created for the purpose solely of this litigation and not created at the same time that the event took place. I might even cut you a little slack if you had a ledger, a book with entries in it at different times from 2017 in different ink, with a day, how much was paid back, how much was paid back on the loan. I guarantee you do not have that. You have a very nice piece of white paper that you created for me. Is that correct? That is correct.
That is accurate.
Okay, so I'm not interested in your ledger. That's not a ledger. That's a document prepared for the purposes of litigation. So I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck. They bought this boat from you.
Accurate.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know I'm not buying your whole story.
Herman and Tina Smoody claim their former son-in-law, Dalton McDonald, owes for unpaid loans.
Now, I want you to tell me what conversation you had and when with Mr. McDonald about paying for the truck.
That was from the very beginning, because I was paying all their bills.
Just a second. I don't care whether you were paying their bills. I understand you were paying all their bills because they came to live with you for a brief period of time because they were evicted for whatever reason, and that was sometime in 2016. Okay. So I understand that you were paying their bills. Well, sometimes that's what parents do. They pay their bills.
We were paying their bills because they had no checking account.
That doesn't matter to me. I want to know your conversations with, where did it take place? Because you're not suing your daughter, you're suing him.
The conversation was when we rented the farm for them, which I know is not with the truck, but the landlord would not let them rent from them because they had terrible credit.
We'll get to the rent later. Stick with the truck. Don't talk to him when I'm asking him questions.
Well, the truck was the same thing. We put that on the ledger then, or on the running total, and they agreed. They both agreed that they were going to pay us off.
Okay.
He came over on Labor Day weekend, and I showed him the ledger, which he saw all the time.
No. Don't tell me what he saw. Don't tell me what he saw. If what you're saying is you showed him the ledger when he came over with the boys,
yes,
and he was going back to Minnesota.
Right.
And he brought the boys to see you to say goodbye?
Correct.
Okay, so far, it's very nice. You have a reasonable relationship with him, and certainly your daughter was clearly overwhelmed because courts do not usually split up children, so they must have felt that the children's best interest would be served if they remained with their father. Clearly what happened, the father came over to you to let you say goodbye to the children, and when he came over to let you say goodbye to the children, let me understand what you're saying to me. What you said to him was, not thank you for taking over this responsibility. Your daughter had more children than she could take care of, physically or financially, right? Clearly.
Yes.
Clearly. So what you want me to believe that two nice people who took in their daughter with her two kids and a husband and bought a truck and made arrangements for them to have someplace to live, that these two nice people, when he came over, because your daughter couldn't take care of her children, and he brought them to say goodbye, you said, it's very nice. I want you to take a look at this ledger and see how much money you owe me. That's what you're asking me to believe, right? I'm going to let you live with that fantasy that I believe that.
And so I did give him the balance of what he owed me on the rent
No.
and on the truck.
Nice.
And
So far,
he looked me in the eye, he shook my hand and said, Jerry, I promise I'm not going to screw you on this. I'm going to make those payments.
make payments for what?
On the rent and on the truck.
Okay. Did you have that conversation with him?
No, I did not, Your Honor. The conversation was when I came up there the last time, Jerry was trying to sell his fishing boat, so I posted it on Facebook, and I sold it for him.
In what month and year?
That would have been September of 2020. After selling the boat, he gave me $1,200 for helping him.
How much did he sell the boat for?
It was $4,700.
So that was after you'd already moved?
Correct.
With the children?
Yep.
Okay. He helped you sell the boat for $4,700? Just answer my question.
No.
Did you give him $1,200?
No. He bought that boat from me a year prior to that. He had it.
So they bought this boat from you.
Accurate.
When?
That would have been in the spring of 2019.
And how much did you sell it to them for?
$2,500.
Did they pay you for it?
No, part of that was put on the ledger, and part of it was cash.
You know, I'm not buying your whole story. I'm not buying your whole story
sorry,
because what
Your
if...
Honor, I'm telling you the honest to God truth.
No, I don't think so. I don't think that I would have sold people who had no credit, who couldn't buy themselves a truck. So you had to co-sign for the only means of transportation that they had, who couldn't pay for their rent, who couldn't pay their bills because of their bad credit. I don't believe this whole scenario about selling them a leisure boat for $2,500. It's mind-boggling that you would think that an intelligent person like me would accept that. Okay, forget the truck. You have the truck now.
Yes.
Okay. You haven't finished your story with me, so sold the boat, and he gave you $1,200.
Correct. I gave him the $1,200 back, which made us even on the truck payment, and he gave me the title. Tina signed it, and then I brought it back to Minnesota and put it in my name.
Okay. Who signed it?
Tina signed it.
My name was on it as well.
Your name?
Yes.
As joint owners with him?
Yep.
Co-signer.
Oh, interesting. In what month did Mrs. Smoody
Yes.
sign over the car to you?
The same day that I gave Jerry the $1,200, that would have been in September.
Now, do you remember the $1,200?
No, it was $1,000 that he paid toward the loan when I sold the boat for him.
Okay.
And it was his boat that I sold for him.
Okay. You did not create this as a marital debt. It absolutely was a marital debt. So I'm dismissing that portion of your claim that deals with the truck. Now, let's deal with the rent. The rent that you're talking about was rent in what property?
The farmhouse that they rented.
From
in
when to when?
2016, November 2020.
And over the years that they lived there as a couple.
Yes.
The rent was paid to a landlord.
Correct.
By you.
Yes.
Is that right?
Correct.
And they, your daughter and her husband, would give you cash, checks, or whatever
Cash,
to
usually.
cover the rent.
Yep.
Yes.
And how much did they give you to cover the rent?
When we started out, rent was $800, and later on he raised it to $900. We never made it a set amount each week. They gave us what they could. And we've done this before in the past, and they've always paid us back.
Well, then you should have sued them and listed all of this as a marital debt in the process of their divorce. So it could all have been...
We're handling
it could all have
Jacqueline
been,
in another way.
You what?
We're handling Jacqueline alone. I
don't understand what that means.
Well, you're saying it was marital.
Just a second. Does that mean that you've already served your daughter with a summons?
Not yet, no.
Of course not. Of course not. And you did know when they were divorcing.
Yeah.
You did know when they
Yeah.
were divorcing. I'm not buying anything of this lawsuit, most of which, at least the rent part, is totally stale. I'm just curious, Mr. and Mrs. Smoody. Somebody wants to answer this question for me. Mr. McDonald has custody of your two young
Yes.
grandsons, who I assume that you were close to because they lived with you in your house. And you seem
to
like...
live with us. The two boys came back to live with us.
From when to when?
December of 2021 until July of 2022. 6 months we had them.
Just a second, 2022. Was there a court proceeding?
No,
But then in July, they went back with their father.
that's accurate.
And they've been with their father since.
Yes,
Okay, so the boys lived with you for 6-7 months.
right.
Was that an acrimonious transfer? That's what you meant when you said Any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee.
Herman and Tina Smoody are accusing their former son-in-law, Dalton McDonald, of refusing to pay back loans.
Was that an acrimonious transfer, or was it something that you both...
What happened there was he called my husband to see if
No, don't tell me what he said to your husband.
Okay,
I will tell you then. He called me in December and asked me if I would please take the 2 boys. I told him, I will take them, Dalton, if you start making regular payments.
Oh, well, we're out of the money business now, sir. What you're saying is from 2017, when the children were in his custody, your daughter may have been there, but they were in joint custody, and then he maintained custody of the children, and during the time he maintained custody of the children, there was no question whatsoever that he was not paying you back money. He did not make any payments to you. Occasional here and there, we don't keep records. All of a sudden, now you have the boys with you. And then in July, he comes back and he takes the boys back. All I asked you was whether that was an acrimonious, which is an unpleasant, or a harmonious transfer of the children. Mr. Smoody was in July.
In July, it was acrimonious because at that point, he'd gotten a restraining order against me.
Against you?
Against me while we had the children. Because I sent him a letter saying that I wanted payment, and he went and got a restraining order against me because they took that as a threat.
I'd like to see the letter, please, Kevin. And this is what needs to happen moving forward.
That's correct.
You need to mail me $200 on the 1st of every month and $200 on the 15th, starting March 1st, 2022. If I do not get these payments on time, the following will happen, which is, you could say, I'm going to sue you, right? I'm going to sue you, but that's not what you say. You say, I will go to your boss and talk to them about garnishing your wages. Any employer that has gone through all the paperwork and red tape, as I have, will do anything to avoid it. So that's a threat. What you're saying is, I'm going to call your boss and tell him that I'm going to sue you, and then your boss is going to have to go through all the red tape of what it means to have a garnish on your salary. You have to go through accounting, and they have to deduct it. And no boss wants to do that, which is in effect say, so either you pay me or your boss is going to fire you. That's what you meant when you said, any employer that has gone through all that paperwork and red tape, as I have, will do anything to avoid it. The anything is firing the employee. The only thing that...
You can legally fire somebody.
Just a second. Whether you can legally fire them or not, that's what you were threatening. That's what that said. So we got an order of protection against you.
Correct.
And?
Then I didn't fight it because I didn't anticipate having any conversations or contact with him.
When you wrote this letter...
Yes.
You had the boys.
Yes.
Right. Not before.
No.
Not before. And he had the boys for some time alone.
3 months.
He had the boys for some time alone. Okay. Let's go back to my original question, which was, when the boys went back to their father, was it acrimonious or harmonious?
It was not good.
Well, so tell me your version of what happened.
The reason it was acrimonious is because he knew very well that once we got him, we put him on a strict schedule. 8 o'clock, brush your teeth, 8:15, pajamas, 8:30, bed.
Where was your daughter living at this time?
With us.
Yeah, just to say, if you're going to interrupt him because you want to get it out,
I'm sorry.
That's not going to be good for you.
She had a room at our house.
Just a second. So your daughter was living with you. So what you're telling me was your daughter was in the wind someplace.
Accurate.
Okay. You had her for a long time. He only had her for 5 years. And I can understand the sadness if your daughter is in the wind and not being responsible, sir. But that doesn't mean he has to shoulder all the burden. Right now, he's shouldering all the burden of supporting the 2 children, which I assume you're doing. They're living with you. And so are you working?
Yes, I am.
And he's working. Your daughter is not.
She's working 2 jobs.
She always has.
If she's working 2 jobs, why was she in a room?
She wasn't renting. She was living there free.
Okay. So now let's get back to this acrimonious transfer of the children back in July.
Dalton called me, or called the kids.
Okay, so he called the
after
children.
bedtime.
Okay.
Called my wife's phone 4 times. Ring, 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 ring. And she wouldn't answer because kids were in bed. And then he called my phone twice. The second time, I have an old flip phone. I flipped it, walked in, because now I hear the boys are awake. I let him talk to the boys. And then I took the phone back and I said some naughty things to him and hung it up.
What did you say naughty things to him for?
Because I was very angry at him. Can I use some swear words that I used when I told him?
No, I assume you used some terrible words.
Yeah,
but
I just told him, don't call me anymore.
Is there any reason that you discussed with your wife why she didn't answer the phone?
Because the boys were already in bed. He had done that before.
You already told me that you heard the boys, so you took the phone into his room.
After the phone calls, they woke up.
Is what you're telling me that the first time that he tried to talk to the boys, that you or your wife didn't answer the phone?
I think it probably happened once or twice prior, and then we told him, don't do it anymore.
Okay, fine.
And this time we were fed up.
Fine. So that's when he said, I'm coming to take the boys.
No.
Well, when did he say he was coming to take the boys?
Not until July. Jacqueline told us that Dalton was going to be taking the kids once they got out of school.
Okay, I'm going to take the pain out of this case, and I'm going to do it relatively quickly. I think, Mr. and Mrs. Smoody, that this lawsuit was very ill-advised. The defendant doesn't owe you any money. He doesn't owe you any money because if there was money owed, it was a marital debt, and it should have been taken up at the time of the divorce, listed as a marital debt, and then it could have been fixed by the judge who approved the divorce how much and by whom is owed money. You chose not to do that. It was only after a very acrimonious set of circumstances, roughly 5.5 years later, after this truck was purchased, that you chose to exercise any prerogatives with regard to a debt, except this letter, which threatens to go to his boss to get him fired if you don't stop making payments, and that was only after the 2 children came to live with you and were sort of overwhelmed. You have to understand, Mr. McDonald, who I think probably is trying, he's got the 2 boys. It got very complicated, but it's not a lawsuit, and I would make nice with him. He's got 2 children that you probably want to have some connection with, and this lawsuit certainly doesn't help that. Well, anyway, for all the reasons that I've stated, your lawsuit's dismissed. We're finished. Thank you.
This court is adjourned.
He owes us that money. He admitted he owed us the money.
I think the judge was absolutely correct.
He promised he was going to pay us the money back.
I don't owe Jerry any money.
Kids are irresponsible, have no sense of honor, duty, respect, responsibility, nothing.
It really should be a family thing, and maybe one day it can go back to it.
This is a great case that explains why a lot of cases in civil court have a statute of limitations before you can bring a certain kind of case, because here it was hard for us to understand why they would not have requested that money back earlier. So when you ask for it now, years down the line where so much has happened, court's not so likely to feed into that because you don't know what the real motivation is behind it.
I agree. I think it's really foolish of them, especially since their ex-son-in-law has total custody of these 2 little boys, for them not to maintain reasonable relationship with him.
It was a good showing, though, that if you do give money to your daughter, son, and their significant other, and they do get divorced, you should follow that divorce proceeding. So if you do have a claim,
a legitimate debt
or claim, then that's the place.
Vehicle owner Robert Pena for damage after his 17-year-old son hit Dean's car.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2076, Miller versus Pena.
Thank you.
You're welcome.
Mr. Pena, is that your son?
Yes, it is.
The one who was driving the car?
Yes.
Okay, good. You stand up next to your father. Mr. Miller, is your claim that the defendant's son hit your car that was parked in a parking lot?
Yes, Your Honor.
And it was parked in the parking lot of a high school?
Yes, Your Honor.
Do you work in that high school?
Yes.
As what?
I'm a teacher.
What do you teach?
I teach what's called on-site continuation. It's a continuation classroom for 10th through 12th grade students.
Do you go to that school?
Yes, Your Honor.
Okay. On what date did you park your car when you allege it was hit?
That was on March 8th, Your Honor.
You were in school that day?
Yes, Your Honor.
Now, you should know that in reviewing this case, Mr. Miller, because he was not there when his car was hit.
Correct.
Correct? And so he alleges that it was you who hit his car and then left the scene. Your father said it was not you who hit his car, and there's no proof that it was you who hit his car. That's what your father said. Before you answer my questions, I'm going to tell you that Mr. Miller has a video that he says was taken by school cameras that were zoned onto the parking lot that demonstrates that you actually did hit his car and leave. Do you understand?
Yes, Your Honor.
So now we're going to go back to March 8th, and you're going to tell me what happened with Mr. Miller's car.
So I drive myself to school every day, or at the time I was driving myself to school because that was my only way of getting to school.
Did you have a driver's license?
At the time, no, I did not have a driver's
So you were driving a car without a driver's license?
Yes, Your Honor.
And what kind of a car were you driving?
It was a 1991 Camaro.
Where did you get the car from?
Me and my dad had gone off the street. It was a project car.
How old are you?
17.
Did you try to take a driving test?
Yes.
When?
Back when I had turned 17, actually, in February of last year.
And you didn't pass it?
No.
Did you take the written test?
No.
What did you take in February?
The practical test.
Just the practical test, the driving test?
Yes.
And you failed that?
Yes.
So despite the fact that you failed that, you drove the car, and your father knew that you were driving the car without a license? That's a yes or a no?
Yes.
Was there insurance on this car, Mr. Pena?
No, there wasn't.
So no insurance, no license. So far, not good parenting. You understand that, Mr. Pena?
Yes.
Great. Okay, so you drove yourself to school and?
There's a parking lot that all the students, teachers, anyone who goes to school, really, they can park
Yes,
at.
nobody suggests you were trespassing in a place you weren't supposed to be.
Yeah, so every morning I would park in...
Not everyone, look at me. That day, Mr. Miller's car.
Yes, Your Honor. That day, March 8th, I came to school as usual and I parked in my area, and then one of the on-school deputies that the school has, he pulled up right behind me as I parked, and he asked me for my information, he asked me for my name, my school ID.
I want to know what happened with Mr. Miller's car.
Oh, nothing happened with Mr. Miller's car.
So what you're telling me is that you did not hit Mr. Miller's car. Is that what you're telling me?
Yes, Your Honor.
What car were you driving that day?
1991 Camaro.
What color is it?
Red.
How long have you been going to that school?
It's my 4th year going.
How many other people drive a 1991 Camaro? Red. Nobody.
Nobody.
And so I'm going to watch this video. Sarah, do we have the video?
I have it. So, there. Wait, you'll see it.
Okay. You had a truck.
Yes, ma'am.
Okay. Okay. So there's no question you hit the truck. Do you want me to show you the video?
No, Your Honor.
Okay. Well, if you don't want to see the video, that's because you told me a lie.
Oh, yes, I'd like to see the video.
Absolutely. Going to watch very carefully, you pulling into a spot and the truck moved as you were pulling in. Have they shown you the video, Mr. Pena?
They showed me a different version of that video.
Well, I've just seen the version that I saw. Got it?
Yes, Your Honor.
Saw the truck move, did you?
Yes, it did.
When you were pulling in next to it?
Yes, I was.
When you were pulling in next to it? So that didn't happen because there was an earthquake. That happened because you hit the truck.
Yes, Your Honor.
Fine. Now we understand each other, Mr. Pena?
Yes.
Great. That's a yes. Okay. Can I see pictures of your truck, please, and the estimate to repair it?
Yes, Your Honor.
Have you seen the photographs?
Yes, Your Honor.
Okay. Totally consistent, right? Okay. Mr. Miller, you're from California?
Yes, Your Honor.
Do you regularly teach today?
Yes.
So you had to take a day off.
Yes, I have a substitute today, yes.
How many days off are you allowed?
10 per year. I've accumulated quite a few because I don't take many days off.
You get paid for those days?
I get compensated because I have sick days or personal necessity days.
The reason I'm asking you these questions, Mr. Miller, because it's no question that you are entitled to have your car fixed. But that's, to me, even though that's all you're requesting, I think the fact that Mr. Pena allowed his son to drive a car without insurance and without a license, not only without a license, but knowing that his son took a driving test the month before and failed it, which means that he was not a good driver. not a good enough driver to get a driver's license. And I have a lot of people in my family that don't drive well, that I don't like to be in the car with. But they all have driver's licenses because they managed to pass a driving test. So I know that you are only requesting the $1,524, but I'm actually awarding you $2,500.
Thank you.
And that's for the aggravation of, instead of Mr. Pena saying to you, I'm sorry, my son hit your car, because either his son lied to him.
Your Honor, can I say something?
Either his son lied to him, or his son told him the truth, but he lied to me. And he's the grown-up. He set an example for his son that said it's okay to break the law. Not only for you, because you take the car to school. Take the car to school, even though you failed. Take the car to school. It has no insurance. If you hit somebody in that car and you seriously injure them, that car has no insurance. Car has no insurance. He has nothing to lose. Car has no insurance, but the person who he hit, person whose property he may have destroyed, they have no recourse. You understand, sir? That's a bad parental example. You want to say something to me or not?
Yes, I do.
I don't care that you didn't like it. That's not, as a parent, the lesson you should be teaching. And whether or not you like the way the sheriff spoke to him, that is totally irrelevant to me.
Later.
I paid as much as I could supporting him. I wasn't getting paid rent for his room.
What happened is you both sort of took advantage of this rent moratorium.
Not true.
Dean Miller claims vehicle owner Robert Pena owes for damage after his 17-year-old son hit Dean's car.
Go ahead.
My thing I didn't like was how he got approached.
I don't care whether you like it or not.
That's what I didn't.
I don't care whether you like it or not. Did your son come home from school that day and say, I hit somebody's car?
No, he didn't.
No, he didn't.
Nowhere.
And just a second. And when you asked him whether he hit somebody's car, what did he tell you? Just be careful.
He said, I think. He felt
Just a
intimidated
second.
by
I think.
the sheriff and him.
I don't care that you didn't like it. That's not, as a parent, that's not, as a parent, the lesson you should be teaching. First of all, you allowed your son to violate the law. You allowed it. And then, I mean, I would certainly know whether I caused that much damage. He knew that that car moved. So either he lied to you or you lied to me. And whether or not you liked the way the school official spoke to him or the sheriff spoke to him, that is totally irrelevant to me. That shouldn't be the takeaway from this. The takeaway from this is you're supposed to follow the rules. The rules are meant for everybody, and that includes you and your kid. Judgment for the plaintiff in the amount of $2,500. We're finished here.
This court is adjourned.
Police officer came behind me when I parked and accusing me that I'd hit someone.
The school deputy saw the video, knew the car, so he approached the student.
The person who I supposedly hit came out with a megaphone yelling at me.
There is no megaphone, so I don't know where that came from.
Telling me that I'd hit him. So I was kind of like freaking out. I didn't really know what to think.
If it happened to me, he could hit someone else. And
I didn't know I hit your car. Like, did I hit your car? Like, I didn't even know what to think. I could have sworn I did not.
This was fortunate that it was just a parked car in a parking lot.
It is time to get his license, yes, that's correct.
It is time to get the car fixed and just get some closure on this.
In our family, we would call that contact a love tap. And as someone who has had a few run-ins potentially with stationary objects, I will tell you.
Not potentially.
I will tell you, you know when you hit a stationary object, even if it's just a light little love tap. So I just thought it was outrageous that the defendants, father and son, they knew that there was a video and still took the position of, nope.
Well, his father's position was, I didn't like the way they spoke to my son, and therefore, I'm not responsible. They shouldn't have spoken to him. I mean, he's 17 years old, but he looks like a man. He's taller than his father, you know.
You have to take responsibility.
But you have to take responsibility and not drive a car, especially. You failed a driving test. The most basic thing. I mean, you know, we have
I will say, I did pass on the first try, so.
Yes, but we have people in our family who actually did not.
Okay, yes.
And they didn't drive. And they didn't drive a car. Yeah. Until they could pass a driving test.
And their parents were the first ones to say, no shot until you pass that test.
Absolutely.
So parents need to be responsible as well.
Right. Case 2104, Birkeland versus Lefkowitz. All party, please step forward.
Shannon Berkland is suing her former roommate, Ian Lefkowitz, for unpaid rent and eviction costs.
Ms. Berkland, how long had you lived in your residence?
Prior to the defendant moving in?
Yes.
2 years.
And how long did you live there with the defendant?
A total of 5 years.
You
With
lived
the
in
defendant, I'm sorry, 3 years.
3 years.
This month would have been.
And for most of that 3-year period, what kind of work do you know that the defendant did?
Computer work and music producing.
How do you support yourself, sir?
I produce music. I don't do computer work.
Produce music for whom?
Various artists and brands and whatever.
How long have you been doing that?
Since I was 13 years old.
How old are you now?
32.
You have a corporation or an LLC?
Not currently standing, but I do have one that is out of commission right now that needs to be reestablished.
When was the last time you filed tax returns?
Last
April.
Last April, yeah.
And on your tax returns that you filed, how much did you indicate that you earned?
I receive royalties from a company called, and they take my taxes out automatically, so I'm not sure how much.
I'm asking you how much you reported your gross income was when you filed your tax returns in April.
They come automatically, is what I'm saying. I didn't file them. They're paid for and filed automatically by the company that distributes my royalties.
So is what you're saying you didn't file tax returns in April?
I assume that they're filed automatically through this company that pays me.
Mr. Lefkowitz, when was the last time you put a stamp on tax returns that you sent to the government?
I do not know.
Ever? You have to think.
No,
ever?
Like I said, where I make most of my money, if not all my money, comes through a company called, which they take out the taxes automatically before paying me. So I've never filed through that. I just assumed that it was already taken care of in that way.
You assumed wrong.
Okay.
Okay. There came a time, Mr. Lefkowitz, you lived there for 3 years, but there came a time when you stopped paying rent.
Correct.
And what was your rent when you moved in with the plaintiff?
$1,200 a month.
You had your own room?
Yes.
Bathroom?
Yes.
You moved in what month and year?
2019 in October.
And as you said, most of your money comes from royalties, and I assume that's royalties on past work.
Yes.
And you've been existing on that for how long?
8 years or so.
So how much do you make from these royalties? You pay $1,200 a month rent, you have a car.
Mm-hmm.
Uh-huh, it's not an answer.
Yes.
You have a car.
How much do I make?
So you have a car, you have insurance.
Yes.
What kind of car do you have?
I have a Honda Clarity.
What year?
It's a lease. It's a 2021.
And how much do you pay a month for the lease?
$395.
Does that include insurance or does it not include insurance?
It does not include insurance.
So you pay an additional how much for insurance?
About $350.
So you spend $700 a month for your car.
Correct.
And let's get back to, you moved in October of 2019, your rent was $1,200 a month. And you lived there until when?
Until about 2 months ago. So September 4th or 3rd is when I moved all my stuff out.
And when was the last month you paid rent?
That would have been in December of 2021.
So you lived there January, February, March, April, May, June, July, August, and part of September. So at least 8 months that you lived there and didn't pay rent.
Mm-hmm. Well, I wasn't there for August, pretty much the
Your
entire...
things were there.
Sure.
If your things are there, you're there.
Okay.
Because that's part of what she's suing for, rent that you didn't pay.
Mm-hmm.
Are you still living there?
No.
Why not?
I was evicted.
When?
The exact date is August 2nd. I do have my paperwork for notice to vacate and all that.
Just a second.
Sure.
On August 2nd of 20...
I'm sorry, that was the court date, and that's when the judgment was made, was August 2nd.
And when did you move out?
2 weeks later.
That's not true.
And you were evicted for non-payment of rent?
Yes, for 2 months. Yes.
Just a second. You were evicted for non-payment of rent?
Yes, for 2 months.
Well, show me that it was for 2 months. I just want to see that it was for 2 months and what 2 months those were.
That page right there.
No, you didn't leave until, let's say, September 1st.
That sounds more like it.
You didn't leave until September 1st.
I'm sorry, Your Honor. I did mistakenly speak. I do remember that the judge...
Don't tell me what the judge said. I'm asking you when you left.
Gave me 6 weeks from that date of August 8th.
What
so I left
date?
September 8th.
And you left at about the same time.
I left prior, but I called my neighbor at...
Just a second.
Yeah.
You left at about the same time.
A few days before.
Fine, that's at about the same time.
She actually left after that. I talked to a neighbor that said around the 14th that she was still there.
You can't tell me what the neighbor said, sir. That's why I stopped you before.
Well, I know there's a moratorium for COVID, and the government shut my business down.
That's what he
so
said.
I knew that I had protection.
He's saying the exact same thing you are in his answer. You two are soulmates.
Hey, no, Your Honor, I'm sorry.
Shannon Berkland claims her former roommate, Ian Lefkowitz, is responsible for unpaid rent.
Okay, this eviction notice is dated May 26, and it says that you didn't pay April or May.
Correct.
But both of you lived there in June. Did you pay June?
Yes.
Show me proof. Show me proof that you paid June and July. Show me proof you didn't pay April and May. Show me proof that you paid.
My proof?
Your proof.
Isn't in the fact that I don't owe any rent except for when the moratorium lapsed and I...
No.
I don't have a receipt. I don't have a receipt for payment.
Then just say I didn't pay rent for June and July.
I did not pay rent for June and
Well,
July.
just answer that question. So you didn't pay rent for
yes.
June and July.
Yeah.
Here we go. And you didn't pay for April, May, June, and July. I know you didn't pay for August. There's no question you didn't pay for August, and you were actually there in August, so you didn't pay for 5 months.
I guess, yes.
Okay, yes. And the reason that you didn't pay rent for those 5 months was what?
I had spent all my savings on paying rent, and I had none left. I paid as much as I could supporting him.
Just a second.
The best I could, and I...
What happened is you both sort of took advantage of this rent moratorium.
Not true.
Well, if you didn't pay rent for April, May, June, July, and August, what were you doing?
Waiting for him to pay his rent because I couldn't afford to pay for my station.
Just a second.
Yeah.
You didn't pay any rent. You didn't say to the landlord, I have a roommate. I can't take care of him. I'm giving you my half of the rent.
Well, I know there's a moratorium for COVID, and the government shut my business down.
That's what he says.
I knew that I had protection.
That's what he says. He's saying the exact same thing you are in his answer.
Did he go to court and do the paperwork and do the filings and
Who cares?
And I do.
Who cares? I don't. Each of you seems to be living. You operate your hair business out of your house.
In addition to another business, yes.
Whatever. You operate your hair business out of the house. He operates, I don't know what he does, but I know he's 32 years old, supports himself, spends $700 a month on a car, spent for a long time $1,200 a month rent, and can't remember the last year or the last decade that he filed tax returns. So whatever it is, this is your problem, Miss Berkland, and this is what I actually didn't understand when I read your complaint, because what you're looking for is 8 months' rent from him.
Correct.
You didn't pay the rent.
I shouldn't be evicted. I asked him to leave every month that he didn't pay me.
Should have read a cutter.
I had a business as a hairdresser, and I went out to rent a station, and I was out for 4 months to pay for a station.
It doesn't matter.
Because I wanted to go back to be my nice space that I had created for myself, and I've worked my butt off for, and my clients liked. I wasn't getting paid rent for his room. I wanted to move my studio into his room and make it my hair salon. So I can have 2 businesses now out of my home. I have 0 income, 0 businesses. My life has not been easy. And this home was the one thing that I've worked my ass off for. It's the only thing in life that I loved besides my
Miss Berkland, did you say to your landlord,
yes,
I have a roommate.
Yes.
He's not paying me his half of the rent, but I want to show you in good faith, I am going to give you my portion of the rent. You didn't do that.
Yes, I did, Your Honor.
Well, show me. Just a second. Show me. All I know is they say this is your evidence for the full amount of the rent for April and May. And I know you didn't pay June, July, August, and September. I know you didn't pay that, so I'm asking you, just show me some proof, Miss Berkland, that you said to your landlord, who is also in business. business of renting space for which they are requesting rent paid in a timely fashion, and then they've got two people who decide, well, we have a rent moratorium. I'm not in any worse position now than before, so I'm just not going to pay rent.
Your Honor, I was...
Just show me that you made partial payment to the landlord for April, May, June, July, and August.
I don't have that because I was protected under the law.
Okay, good. And so is he. Case is dismissed. We're finished. Goodbye. Goodbye. Listen,
I can prove
you
to
two
you
are so.
that
You're
I
just.
attempted
You're
to
just
pay full rent. After
you
he
two.
was gone, and I was able to bring my business into the house.
You two are soulmates.
pay.
You both relied.
No, Your Honor, I'm sorry.
Out.
This court is adjourned.
Soulmates. You both took advantage of a law, and you both lost. Goodbye.
I have nowhere to operate both of my businesses. I created one during COVID.
We both exercised our rights under California tenant laws.
Which I would have had I had a room that he wouldn't leave.
You know, that's just what it is.
Every month I pleaded with him.
That never happened.
I cried, I fought.
She never asked me to leave crying, approached me, nothing.
If it can be helped, don't have a roommate.
I'm glad you didn't give her any money. But if you were going to award any money in this case, it should go to the landlord, because the plaintiff did the exact same thing using the exact same legal loophole that was created during COVID for people who really were struggling and not being able to afford their rent. And now she sues him for doing the exact same thing that she did. So the landlord is really the only one out here.
That's correct.
Yeah.
And if he could write a check to the landlord, that would be fine. But the landlord isn't a party. I have a feeling that there are a lot of very small landlords, not people that own giant buildings, but people who have, their real estate businesses are small. They may have 2 or 3 or 4 apartments that they rent. They maintain them, whatever. She was living there for a while, clearly happy with the situation because she lived there for 5 years. Well, why just not pay your rent if you're still doing hair in the apartment? That's a business. That's what you're doing. He's still collecting his same royalties, which he thinks somebody else should be reporting on their tax return. I don't know. People have to really grow up. I'm getting so... losing my patience so quickly.
Maybe I'm losing it a little young.
Maybe. I think I'm tarnishing you.
Isaac Uno is suing his former tenants, Ann V. Kelly and Kevin Jackson, for unpaid rent and property damage.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2116, Uno versus Kelly Jackson.
Thank you.
You're welcome.
Mr. Uno, you purchased a duplex home, 2 different apartments.
That's correct.
In what month and year did you purchase the home?
November of 2020.
And when you purchased it, one of the duplexes was occupied by the defendants.
That's correct.
It is your claim that they owe you for rent?
Yes.
And for property damage?
That's correct.
They are no longer there?
No.
Mr. Jackson?
Yes.
How long were you and your wife living in the duplex before November of 2020?
We moved in June of 2019.
And at the time, do you recall who your landlord was in June of 2019?
Yes.
Between June of 2019, when you first moved in, and November of 2020, when the plaintiff bought the property, was there any work done on that property?
Not at all.
No maintenance?
No maintenance.
Okay. So from the time you moved in, the prior owner did no maintenance on that property? Did no painting?
Oh, just the minor stuff before we moved in. They just painted and just had everything looking nice, the floors.
So just a second. So the prior owner painted the premises and did the floors?
Yes, it was carpet and some flooring in the kitchen.
And Mr. Uno did not do any other painting or flooring or any cosmetic work on the duplex when he purchased it in November of 2020?
No.
So whatever was there by the previous owner of the property is still there?
Yes.
I'm just asking you this because your counterclaim is for child endangerment, and the child endangerment is because of lead paint. That's what you write here.
Yes.
He didn't put in the lead paint, right?
Yes, thinking about that.
He didn't paint it. You don't know when it was painted. Maybe it was painted by the prior owner. How do you know? By the way, do you have medical records of the child that you claim has lead poisoning?
Yes.
I'd like to see them.
asked him to fix it. So the things we had, like to get the tub fixed, the flooring and everything, he told us to take back.
How many people were living in the duplex?
In our apartment?
In your apartment?
Four.
Four. Including the baby?
Yes, ma'am.
Including the baby. And how old's the other child?
She's 14.
Okay. Do you have that report?
No, this is just stating where it was at.
The health department?
Yes, I thought that piece of paper that I gave you was that one.
No.
This is just
doesn't say
This is just showing where the lead was found in the house.
How old is this duplex?
It was built in 1906, so almost 115 years or so.
Yeah. And they certainly used lead paint
Possibly,
then.
yeah, I'm not sure about it.
I'm not sure.
I don't
But,
understand about it.
Ms. Kelly, Mr. Jackson, that's not his fault. That's not his fault. So now I would like to know, Mr. Uno is suing you for rent. And I'd like to know first, how much rent were you paying?
$750.
And that's what you were paying under the old lease?
Yes.
And were you current on your rent when Mr. Uno took over the property?
Yes.
In November of 2020?
Yes.
So far correct?
That's accurate.
When did you stop paying rent?
December of 2021.
So you paid rent for a year?
Yes, ma'am.
Were you working, Mr. Jackson?
Yes, when I first moved in, yes, I was working 2 jobs.
And were you working from November of 2020 to December of 2021?
Yes, I was. It was.
For whom?
Yes, I was. I was working for TGI Fridays.
And Ms. Kelly, were you working?
No, ma'am, I'm disabled.
And how much were you receiving in pay?
I was only getting...
If you have to think about it, you don't remember.
Yeah, I wasn't getting too much because it was during COVID, and I was working at a restaurant, and I was only allowed to work 3 days out of the week.
Okay. And what happened in December of 2021?
What happened was he already sent us a letter previously saying that he wanted to go up on the rent to a...
Okay.
Yes, to
so you had no
$1,000.
lease anymore, and he wanted to raise the rent. Okay. I believe you. And that was the reason that you used to try to evict them before?
Yes, that was the first one, but I don't agree with his statement.
Well, what statement don't you agree with?
Isaac Uno claims his former tenants, Ann V. Kelly and Kevin Jackson, owe for unpaid rent and property damage. Ann V. and Kevin are countersuing for child endangerment and a constructive eviction.
And in what month was that?
He sent it to us, I want to say...
Do you remember, Mr. Uno?
It was 90 days before the 1st of December, so that would have been, I think, September 31st or October 31st. Maybe.
That he was raising the rent to what?
To $1,000 a month.
Effective December.
Yes, December 1st.
And what happened in December?
We were, at that time, looking for a new apartment, and at that time it was hard because around that time, a lot of the rent was going up from just being like $800, $900 to like $1,200 to $1,400 for rent for a month there.
Don't speak.
Okay.
And that was, why we stopped paying rent, because we were actually looking for a house, even when he gave us the 90 days.
Okay. So, Mr. Jackson, based upon what you just told me, so stop shaking your head, based upon what you told me, your landlord gave you 90 days notice that if you wished to stay on, he was raising your rent to $1,000 a month.
Yes.
And you started to look around for a new place.
Yes.
And the new places were very expensive.
Yes.
And you didn't find a place.
No.
So you decided to stay in this place.
No.
So what did you do?
We...
So if you didn't find a place
we decided
in December...
we was trying to stay there until we found a place.
I assume they paid rent in September.
Yes.
Oh, yes, yes.
In October?
Yes.
Yes.
They paid rent in October?
Yes.
Good. And November?
November was the last month that they paid.
So they paid in November?
Yes.
So you stopped paying rent in December of 2021?
Yes.
No, you cannot.
Okay.
If I need you,
Yes,
I'll
ma'am.
come to you.
Okay, yes, ma'am.
Okay?
Okay.
Because so far he's doing fine. You stopped paying rent in December of 2021. Tell me why.
We didn't want to live there ourselves anymore either, but it was just a lot of things going on at the house. Like after my father passed away, and he first gave us the first eviction notice because he gave us more than one.
Just a second.
Okay, I'm sorry.
We're skipping over.
Okay.
He didn't give you an eviction notice, I assume, until you stopped paying rent.
No, before December, he gave us like 3 of them, I think. I want to say 3.
Really?
Yes.
Why were you trying to evict them before?
They had torn up the carpet upstairs. It was a moratorium for evictions, but there was a stipulation that emergency evictions for nuisance tenants could be granted before then.
Is there any reason why you took up the carpets?
Yes, the same thing before he took over. Everything was in the house before that, and we complained to the previous owner that the carpet was already dirty. They said that they were going to come and shampoo it, but never did. Like, we would walk and our socks would be black, our feet would be black, so we wanted to take the carpet up. It was dirty to us. And I myself actually told him about it. I went downstairs to his apartment because he lived downstairs from us. Talked to him about it. He came upstairs and I showed him a section of the carpet that wasn't even connected to the floor. You can lift up the whole carpet and like across a whole section of the wall. And then when I did that, he seen that the hardwood looked kind of decent. And then instead of putting new carpet on, he wanted the hardwood to get sanded down and just get stained and and lacquered over.
So you took the carpet off?
Yes.
I believe you. Sounds right, Mr. Okay. And that was the reason that you used to try to evict them before?
Yes, that was the first one. But I don't agree with his statement.
Well, what statement don't you agree with?
Well, a number of things that he said. I didn't authorize him. We spoke. I asked him in the first meeting if there was anything that they wanted to have spruced up or anything as a good gesture, and they took it upon themselves to take up the carpet without my permission.
Okay, not a huge deal. Not a huge deal. You can use it as a huge deal if you want your tenants out because, you can re-rent that duplex for substantially more money.
It was more about their conduct, that they were being very disturbing behavior and just being off the wall. So I wanted them out for a lot of reasons.
Well, I know, but only one of them qualified under the eviction moratorium.
Yes, for emergency of dismantling the
Only
place.
one, and that would have been the carpet. Okay, Mr. Jackson.
Yes.
I'm back to you, sir. I haven't figured out yet. You stopped paying rent in December, and you moved out in what month?
We didn't move out until June.
June. So January, February, March, April, and May. Let's say 5 months' rent that you didn't pay, correct?
Yes.
Why?
Can I speak, Your Honor?
No, him. Tell me why you didn't pay the 5 months' rent, Mr. Jackson.
We just figured that, we didn't figure. We didn't want to pay him $1,000 because to us,
Okay, so let's say you didn't want to pay him $1,000, even though you just told me finding another place would be more expensive, right? You said $1,200, $1,400, but you didn't give him $750. You gave him $0 for those 5 months. So I'm going to come back to you, Mr. Jackson. Does your wife receive disability payments because of her disability?
Yes.
Yes. How much a month?
That I don't know.
How much a month do you receive, Ms. Kelly?
$1,000.
$1,000. And did you continue to receive that $1,000 every month from December until June?
Yes, ma'am.
You see, certain things remain constant. Your disability payments remain constant.
Right.
If you live in an apartment and you have the same sort of income, then you pay rent.
Right.
And if you didn't pay $1,000, so I hear you. Well, that's what he said he wanted. And he's the landlord. And he's allowed to do that if you're going to stay in his premises. But you paid nothing, Mr. Jackson, and that's what I don't understand.
Well, the furnace was busted.
Just a second.
Yeah.
Miss Kelly.
Sorry, I'm sorry.
What? You paid nothing.
Yeah, nothing.
Where did you move in June?
Moved in the same area, like probably 10 minutes away from that particular street.
Is it a private house or an apartment?
It's a house. Well, it's a duplex as well.
Duplex. So the same sort of setup. And how much rent are you paying?
Pay $950.
So almost as much as he wanted in his rent. But are you more comfortable in that unit?
Yes.
Okay.
My wife walked down there and asked, was he the landlord? He just said that he was the building manager. So nobody even got rent for the month of November when we lived there, not him or even the previous people, because he didn't even come upstairs and introduce us.
Well, I wouldn't complain about that, sir, if you're ahead of the game so far.
Isaac claims his tenants, Ann-V. Kelly and Kevin Jackson, owe for unpaid rent and property damage. Ann-V and Kevin claim Isaac forced them to leave.
Now, you saved over 5 months, let's say minimally $750.
$37.50.
$37.50. Now, Mr. The only question that I have to ask you is, Mr. Jackson and Miss Kelly say that they filled out some sort of forms for rent relief during COVID, and you signed it. And they say you received money from the state for any unpaid rent. Did you receive any money from the state for rent that they didn't pay?
No, I approached them with an application, but the program that funds the landlord relief for the moratorium was only open for 1 month, and I came and went, and I missed it, and I never got it. So I did have them fill out something. It was just a hardship thing, but they didn't give me the money for it. I never received anything.
So you didn't receive any money. So far, Miss Kelly and Mr. Jackson, you owe Mr. $3,750 for rent that you didn't pay while you occupied his premises. You, your furniture, your children, I don't care what it is. That's what you didn't pay. And you can't save up your money and not pay your landlord. That's his business. Just like you work for Fridays and you get your pay when you're supposed to, that's his business. He bought a house. He was counting on the income from that house to pay some of his expenses, and you didn't pay it. Well, there's no question you have to pay it. Now you have a counterclaim. I've already gotten rid of child endangerment. This is 150 years old. Constructive eviction. So I'd like you to tell me your allegations of constructive eviction.
Is that like from him not doing anything to the apartment while we lived there?
I assume. You say you were constructively evicted.
Yes, he...
But you didn't leave.
Yes, he has a couple of text messages in here where he says that he actually came up to the apartment to check things. He brought up plumbing, when he first got there in November, we didn't have a working toilet until...
Just a second.
Oh, yeah, I'm sorry.
So before he bought it, is that what you're telling me?
I mean, not before, I'm sorry. When he got the apartment in November, the previous owners, we were trying to contact to see who we pay for rent.
Just a second.
Okay, yeah.
He bought the duplex in November of 2020.
Yes.
Is what you're telling me, Mr. Jackson, that certain things weren't working prior to his purchasing the property?
No, I'm sorry. I want to take that back. After he purchased it, we didn't even know he purchased it because he was living downstairs, and my wife walked down there and asked, was he the landlord? And he just said that he was the building manager. So nobody even got rent for the month of November when we lived there, not him or even the previous people, because he didn't even come upstairs to introduce us.
Well,
but,
I wouldn't complain about that, sir, if you're ahead of the game so far. If you didn't pay rent for November. You didn't pay the prior landlord, and you didn't pay him. So far, you're ahead $750. Okay, keep going.
To go back to the November, so during November, our toilet got stopped up, like right before Thanksgiving.
So shortly after he purchased it, he hadn't been up in the apartment, right?
No,
just you, your wife, your teenage daughter, and the baby.
Yeah, and the kids.
Okay, and the toilet got stopped up, and
he brought in a plumber, and then the guy found out that my son put a little toy in there, and he actually got
so
the out.
Toilet was broken by your son. Okay, so now the plumber said, here's the toy. Kid threw a toy down the toilet. Not an unusual, and
then the very next month in December, my son didn't put anything down there. The toilet started acting up again. It wouldn't flush for like all the way up until the next year, and it never got fixed. But it was from...
Well, you had to have, sir, you lived there with 3 adults. So there had to be a functioning toilet in the house.
It wasn't functioning.
So where did you go to use a functioning restroom?
Her mom lived up the street from us, so sometimes we lived up the street, or sometimes we would just still use the toilet.
Okay. You owe him $3,750 for rent that you didn't pay. Counterclaims dismissed. We're finished. Thank you very much.
This court is adjourned.
I had to collect money, monetary judgment to the courts.
Him being the landlord, he left us like living in crappy conditions.
It was a unbearable situation that I was going through with the noise and the disturbances.
Yeah, he never came up there at all to fix anything.
And the destruction of the property.
He just started making up so many rules, to make it uncomfortable for us to live there.
Well, it was, it's pretty quiet now.
That man is crazy. I'm glad it's over with.
You know what I think is interesting, Sarah, with these cases, we've had a lot of them. The forgiveness that the government wanted to show to people who were having trouble during COVID, work-related trouble, didn't have the same income, and didn't want to have a whole bunch of dispossessed homeless people. It came from a good place, as did some of the monies that were sent out by the government to sort of help people over a difficult time during the height of COVID. But then there are other people who suffer as a result of that, like a landlord who buys a property, a duplex property. Part of it is for income so that they can pay off mortgage, taxes, lawn service, whatever you have to pay on a house. And then the defendants, who really had no changed circumstances that they indicated to me. He was working, she was getting whatever she gets from disability, which is not insubstantial. I don't know if they get any other assistance for any of their other children, but certainly they moved into a place that's more expensive now, that's not far away. They just decided not to pay rent. And I don't think that that is the spirit of what either the federal government or the states who enacted it meant to happen, because the plaintiff owner of this property has rights too. Yeah. You've taken away a right of his.
I agree to an extent, but I also think that that's more a problem on the government's implementation of the moratorium in the first place. That's what ended up hurting the landlord. These people were simply taking advantage of a legal loophole that was created for them. He was in the restaurant business, which, as we know, was one of the toughest hit by COVID. Right. She was on a fixed income that wouldn't be enough to cover, well, barely enough to cover the rent on its own. And then they have to support themselves, feed themselves. They have 2 children. So I'm sympathetic towards the taking advantage of a legal loophole. So I don't know, if I was in your position, I might have decided differently.
Okay.
But that's okay.
All right.
We can agree to disagree.
That sometimes happens.